Hello, ladies and gentlemen. My name is Isaac Christopher Lubogo. Today, we want to talk about the philosophy of law, what other people also call jurisprudence, and I'm going to relate that to jurisprudence in terms of what's happening now, in terms of AI, perhaps in terms of what they call Musevenomics. Some people argue in terms of that, in terms of the Red Power movement. But let's start by understanding what jurisprudence means. Jurisprudence basically is also understood to mean that it is the philosophy of law as opposed to the law philosophy. Now, first of all, understand that the law philosophy isn't recognized in terms of a field of study. Instead, the philosophy of law is a discipline that addresses questions about the nature of law and its philosophical implications. So you should not be confused when you're arguing in terms of the philosophy, in terms of the broader field. So we'll understand that it will encompass branches, including the philosophy of law. So basically, the philosophy of law, or jurisprudence for that purpose, is a branch of philosophy that is dedicated to the study and the analysis of what they call fundamental concepts and principles of law. So it devolves into various aspects of the legal system, aiming to understand its nature or purpose, moral and even ethical foundations. And I'm going to give you some key pointers about the philosophy of law. Number one, when you comprehend the philosophy of law, you must understand the nature of law. So one of the primary goals is to uncover the essence of law. What happens is that philosophers of law usually seek to define what law is, its components, and how it differs from other forms of social control, even other norms. Other things they look at is in terms of what they call the moral and ethical foundations. And here we will try to explore the moral and ethical justifications in terms of the legal systems, in terms of the specific laws. So philosophers usually ask questions about the relationship between law, morality, as to whether all just laws must actually be moral. And that is something we'll comprehend. And then we also argue in terms of what they call the origins of law. Jurisprudence investigates the origins of law in terms of determining how legal systems, for example, develop over time. And this includes historical, sociological, and even anthropological in terms of the perspectives of law as it were. So we probably want to comprehend what is legal positivism versus natural law. It basically would address the debate between what they call legal positivism and natural law. Legal positivists usually argue that laws are valid if they are enacted and recognized by authority, while the natural law theorists believe that the law should actually be just and morally right. And we're going to have interesting discussions and examples in terms of that perspective. And then if you argue in terms of justice and equity, the philosophy of law contemplates issues of justice in terms of fairness, in terms of equity within a legal system. So it questions whether, for example, law should actually aim for equality or utility or some other standard in terms of fairness. Yeah. Now also we will argue jurisprudence in terms of comprehending the role in society, and so we'll understand that the philosophy of law is also crucial for policymakers, for example, judges, lawyers, and citizens, because they provide a foundation for critical thinking about legal systems. So it helps us shaping law that are just and even socially beneficial. So it's very, very important for us to understand the improving of law today. So the philosophy of law basically will help us contribute to the improvement of modern legal systems by encouraging thoughtful reflection and even critical analysis. So it helps to identify inconsistencies, biases, and areas where the law may need some kind of reform. And that's a very, very important aspect. In terms of legal reform and ethical progress, by questioning, for example, the moral and even ethical aspects of law, the philosophy of law can actually help us to inquire into its legal reform, and it helps us play a significant role in terms of advocating for human rights, for example, civil rights, and other ethical advancements in terms of the legal system. Now listen, the philosophy of law can also be helpful in terms of legal decision making, for example, in terms of judges and legal practitioners who often draw upon what they call philosophical ideas to make decisions in terms of ethical and what they call moral reasoning. In terms of informed, jurisprudential thoughts that can actually guide fair and just legal judgments. Yeah. So, in conclusion, someone can argue that the philosophy of law is essential in terms of comprehending the nature and the purpose of law, and it will help us to address what they call the moral and ethical questions and the guiding development and improvement of our legal system. So, it helps us play a vital role in terms of shaping what they call a just, equitable, and ethically sound legal framework that benefits society as a whole. And therefore we'll comprehend that numerous proponents and philosophers have actually contributed to the definition of law and have actually advanced various theories in terms of the field of jurisprudence, or what other people call philosophy of law. So I'm going to give you some notable proponents and their approaches in terms of the definition of law. And we will bring even the contemporary ones, like I was arguing. Let's begin with a guy called H.L.A. Hart. He was a legal positivist. Hart is known for his legal positivist theory, which emphasizes the importance of social rules and the concept of a rule of recognition. So he argued that the validity of law depends on whether it is recognized and applied by a recognized legal authority. Yeah, we'll argue others in terms of as we continue. When you look at another guy called John Austin talked about what they call the command theory. Austin theory, often referred to as called the command theory, holds that laws are actually commands issued by the sovereign authority, backed by a threat of punishment. And in his view, the essence of law lies in the idea of the command. Yeah, and that's interesting. Not so. Look at a guy called Lon L. Fuller. Fuller argued in terms of morality and law. Fuller argued that the law should actually be based on moral principles, and that there is an intrinsic connection between law and morality. His emphasis is actually in terms of the importance of the rule of law and the need for laws to be clear, consistent, and just. Yeah, just giving examples of different proponents. Yeah. Then there's a guy called Ronald Dawkins. He basically argued in terms of rights-based approach. Dawkins' theory emphasized the importance of rights and principles in terms of interpretation of law. He argued that judges, for example, should consider both rules and even principles when making legal decisions, and that they should aim to provide the best moral interpretation when it comes to law. Interesting, not so? And another interesting guy called Thomas Aquinas. He argued in terms of the natural law. Aquinas was a medieval philosopher who contributed to the natural law tradition. He actually believed that the law should actually be based on reason and morality, and that just laws are in harmony with natural law principles, a little bit like St. Augustine, as we shall see. Another guy called Jeremy Bentham, who argued in terms of Unitarianism. Bentham's Unitarian theory basically evaluates the good of the laws based on their utility and the principle in terms of the greatest good for the greatest number. He believed that the laws should actually aim to maximize happiness. Some of you who listen to my YouTube on how to get away with murder, I make a disposition of that kind of argument. And then another guy called John Rawls, in terms of justice and fairness. Rawls' theory of justice emphasizes in terms of fairness and in the protection of individual rights. He proposed the veil of ignorance as a thought experiment to design just laws without actually knowing one's own position in society. So those are just basic examples of some of the people who are what we call philosophers who have actually contributed to the richer tapestry in terms of jurisprudential thought. Obviously, there are different perspectives and insights into the concept of law as legal scholars helps us to draw particular theories and even inform our legal practice in terms of policy development. And I'm going to still try to comprehend some of the arguments in terms of legal positivism, for example, and natural law as two contrasting theories in terms of the philosophy of law, and how they offer different justifications in terms of perspectives on the nature and the validity of law. I would like to start that as my entry point, and then we'll talk about others as I just promised you. Now, if you're arguing in terms of legal positivism, then you need to understand that, as I said, legal positivism has actually been associated with philosophers like John Austin, H.L. Hart, and even Joseph Raz. Yeah, and the justification for this kind of theory, or perhaps jurisprudence, is in terms of what they call the separation of law and morality. So these legal positivists argue that the law is a social phenomenon, yeah, and its validity is not dependent on moral considerations. They even assert that laws are valid if they are actually enacted by a recognized authority, for example, a government, and followed by a legal system in terms of rules of recognition, yeah. And in terms of empirical focus or observation, they emphasize that laws can actually be observed and studied empirically without the need for moral evaluation. So this approach allows, according to them, what they call a clear and objective analysis of the legal system. Now, if you argue in terms of their relevancy, applicability in terms of what they advocate for, legal positivism is relevant in terms of understanding and analyzing the positive in terms of the enacted law in modern legal systems. So it has actually been used to explain how legal systems, for example, operate to maintain a clear distinction between law and morality in terms of facilitating the objective and in terms of the application of the objectivity of the law, as it were. Now, if we go to my interest a little bit, is the natural key proponents like Thomas Aquinas, Hugo Grotius, and other people like John Finis, for example, argue in terms of the proposition of what they call a natural law theory. And in terms of a justification, if you argue them in terms of a justification, then it is important their argument is based on what they call inherent morality of the law. And natural law basically proponents argue that there is an inherent connection between law and morality, yeah, and therefore they believe that law should actually be just, it should be moral in accordance with fundamental ethic principles, and natural theorists actually assert that unjust laws are not truly laws at all. I'll give a quote to that effect of one of the proponents. In terms of universality, in terms of the application, natural law is based on the idea that certain universal ethical principles, often derived from reason or divine order, should actually guide the creation and the evolution of such laws. Yeah. If you had to argue natural law in terms of relevance, then you would quick to understand that natural theory remains relevant in terms of discussion of justice, in terms of human rights, and the moral underpinnings of law. So it has been very, very influential, by the way, in shaping what they call legal principles, particularly in cases where there is a perceived conflict between positive law and moral or even ethical consideration. So it's very important, my friends, that the relevance of these theories can actually vary, as I said, depending on the legal context and the values of society. As I said, legal positivism is often used to explain how laws are actually created and applied in many legal systems, emphasizing the separation of law from what? From morality. Natural, on the other hand, provides for a foundation in terms of discussions of justice and ethical principles within the law. So in practice, these legal systems often incorporate what they call elements, both perspectives and debates about the relationship between law and morality. And these are going to continue shaping our legal philosophy and jurisprudence in terms of that components. Yeah. I'm going to argue some other notable quotes because when we probably hear so many quotes from different people, from some of these key proponents in terms of legal positivism, for example, and natural law, that highlight their fundamental concepts. Yeah. For starters, we may well begin with legal positivism in terms of what did who say, and what did they say in terms of that. If you're looking at a guy called John Austin, John Austin is known for a serious quote called "The existence of law is one thing, its merit or demerit is another." Yeah, that's a good quote for you to begin with. I'll explain a little bit what those mean later. H.L. Hart, for example, is known for his quote that there is no necessary connection between law and morality. Yeah, obviously we understand where he's coming from. And John Raz, on the other hand, made a beautiful quote. He said, "To be a legal system, a set of rules must actually be grounded in the official acts to determine it and identifiable group of people." Yeah, interesting argument there. We'll comprehend what all those things mean. In terms of natural law, what comes to mind in terms of Thomas Aquinas, he's probably one of the most popular quote had to do with an unjust law is not law in the full sense of the word. It remains merely the appearance of law. Is that a beautiful one? Not so. And then you look at a guy like Hugo Gracious. Hugo Gracious said, "Natural is so immutable that it cannot be changed, not by the will of the prince, nor any other power." Interesting arguments, not so. And then if you have to make a beautiful quote by John Phillips, on the other hand, he said, "Natural theory holds that law and morality are deeply connected, if not identical. And law, on this view, is the dictate of reason." I think I would agree. As I said, perhaps my bias is in that context. So I'm just arguing that these quotes reflect a core principle in terms of the legal positivism, emphasizing the separation again of law from morality, and natural law emphasizing the intrinsic connection between law and morality. That is something that must come out very clear, and therefore they offer insights into the philosophical foundations of each of these perspectives. Yeah. Now, if we were to delve into the meaning and practical implications of each of these quotes in terms of these key proponents, first of all, from a legal positive view to natural argument. Yeah, I would argue and say the following, beginning with John Austin. Yeah, because it will help us comprehend what these guys said and what exactly they mean. And I'm borrowing from their quote where he says that John Austin, where he says that the existence of law is one thing, its merit or demerit is another. In terms of explanation, what John Austin was actually saying, John Austin's quote highlights a fundamental aspect of legal positivism, yeah, the separation of law from morality. And he's actually emphasizing that the existence of a legal rule or system is distinct from its moral value, yeah. So in other words, something can actually be considered a valid law even if it's morally objectionable, yeah. That's an interesting one, not so. If I'm to argue that in terms of giving a practical example, consider, for example, a country with a legal system that actually enforces a law requiring people to pay taxes, okay, on their income. From a legal positive perspective, this law is actually considered valid because it has been enacted by government and is part of the legal system. However, whether individuals view this law as, morally just or unjust is a separate question. Some may argue that taxation is actually morally, necessary for the functioning of society, while others may actually find it morally objectionable, right? So these examples illustrate the distinction in terms of the existence of law, in terms of its validity as a legal rule and its moral merit, right? Okay, I'm going to give another example in terms of natural school of law, as it were. And I would like to look at Thomas Aquinas' quote so that we can make also an explanation in terms of that component. The popular one by Thomas Aquinas was, an unjust law is not a law, okay? In the full sense of the word, it remains merely the appearance of law. And in terms of explanation, what this gentleman was saying, Thomas Aquinas, basically his quote expresses a core idea of what they call the natural law theory, which is the intrinsic connection between law and morality. So according to this perspective, a law that is fundamentally, unjust or morally wrong cannot be considered a true law. Yeah? Now I'm going to give an example for purposes of emphasis. Now, in terms of an example, during, for example, the civil rights movement in the US, which was the most, eminent, there were laws that enforced what they call racial segregation, also known as the Jim Crow laws. Okay? So natural law theorists would actually argue that these laws were unjust and therefore not true laws in the moral sense. They would actually contend that individuals had a moral duty to resist such laws on the grounds of their inherent injustice. Yeah? So this example basically illustrates how natural law theory emphasizes that not all enacted laws should actually be considered legitimate if they violate fundamental moral principles. Yeah? So the basis of our discussion here is to understand that these quotes, as I said, represent the core principles of legal positivism and natural law in terms of emphasizing their respective stances on the relationship between law and morality. In terms of legal positivism, as I said, it separates the two, while natural law theory possesses an inherent connection with the moral quality of law being a fundamental consideration. Yeah, and as I said, the practical examples that I gave will demonstrate basically how these philosophical perspectives can actually be applied in a real world situation in terms of implications that they have on evaluation of laws. Yeah. Now I'm going to give you some more practical examples to illustrate some of these more detailed components in terms of legal positivism and also natural law again. It will help us to comprehend. And as I said, be braced for a beautiful discussion. We'll get into the jurisprudence of AI, and we'll be amazed at how jurisprudence now is taking another trend in terms of the modern jurisprudence. Now let's begin with H.A. Hart again. His quote was that there is no necessary connection, for example, between law and morality. And what H.L.A. Hart underscores is that from a legal positive perspective, a law can exist independently of its moral content. Yeah. So laws are valid if they are created and enforced by a recognized legal authority, and their moral quality is actually a separate consideration. Yeah. If I'm to give an example, in many countries, for example, there are laws that regulate and permit activities that may have moral or even ethical dimensions. For instance, consider laws that related to the sale and consumption of alcohol. In terms of legal positivism, they would assert that these laws are valid because they are connected, they're enacted by government and are part of the legal system. So the moral assessment of whether alcohol consumption is actually virtuous or detrimental is not, a concern of the legal positivism, as it were. So it's a matter of individual or societal moral judgment. Yeah. Now, if you had to argue that, if you look at an example in terms of natural law, I would want to argue in terms of a guy called John Finnis, as I explained to you, and to look at the quote that is popular with him is natural law theory upholds that law and morality are deeply connected, if not identical. Law, on this view, is the dictate of reason. Yeah. Let's explain what John Finn's quote escapulates. The natural law theory, in terms of perspective, that law and morality, for example, are intimately intertwined. Yeah. So according to his view, laws should actually reflect what they call moral principles and should be in harmony with reason and ethics. If you argue that in terms of practical example, we'll argue and say that human rights often, reflect the principles of natural law. Yeah. So I'll give an example. The universal declaration of human rights, for instance, is grounded in the belief that certain rights are inherent to all human beings based on their intrinsic dignity, right? So natural law theorists argue that these rights are not mere legal constructs, but rather moral imperatives, yeah? So therefore, when countries or organizations adapt and enforce what they call human rights laws, they are in the natural law view, recognizing and implementing principles of justice and morality in the legal sphere. And that is something that is very strong, not so. Yeah, we hold this truth to be self-evident, according to the Americans, that all men are created what? Equal with certain alienable rights, unalienable rights, not so. So these examples will help us illustrate how legal positive, for example, natural law can actually lead to different conclusions in terms of perspectives on the validity, in terms of the morality of the law, and and positive basically concerned primarily with the formal aspects of law, as I said, while natural law basically places strong emphasis in terms of the moral, in terms of the ethical context, in terms of the legal rules and principles. So these differing perspectives actually continue to shape our legal philosophy and influence our legal systems and even decisions. I'm going to give you some other examples again to describe the discourse between legal positives and natural, because these are the ones that strongly come out. And why I'm making that, you'll understand, because almost every society has either argues in terms of legal, and it appears as if the majority of people tend to argue in terms of natural. I don't know, but we shall see. Let's look at what Joseph Raz says. Joseph Raz, as a legal positivist, his probably most popular quote was, to be a legal system, a set of rules must actually be grounded in the official act of a determinate and identifiable group of people. Yeah? If you had to explain what this guy was saying, Joseph Raz's quote basically was emphasizing that according to legal positivism, a legal system is characterized by its source in the official act of a recognized authority. So the focus is on the formal institutional aspects of the law. Yeah? And if you're arguing in terms of practical example, then we want to consider what they call a constitutional democracy, for example, where the highest law is the constitution, yeah, as the grand norm, right? So according to legal positivism, the constitution is the foundation of the legal system because it's grounded in the official act of the people's elected representative. Vox populi, Vox Dei, the voice of the people become the voice of God, not so. So the Constitution sets out the structure of government, establishing rights and responsibilities, and provides for the framework in terms of enacting or even amending the people. So in terms of legal positivism, it doesn't require that these laws actually be morally just. Their validity basically is based on the proper enactment through recognized legal procedures. Obviously, we shall argue the government of the people, by the people, for the people, so that is another question of debate. If you are to argue again in terms of a practical example, I'll give an example in terms of the natural law. Thomas Aquinas, again, an unjust law is not a law in the full sense of the word. It retains merely, the appearance of law. His saying is a bit popular with one of St. Augustine, and I'll make that discourse as well. As I said, Thomas Aquinas' quote reaffirms that in the natural law view, laws that lack moral justice are not genuine laws. Instead, they are seen as mere legal pretenses. Yeah, I would like to agree with my bias, as I said. If you're arguing in terms of practical examples, during the times of, for example, societal upheavals, there can be what they call unjust laws that suppress fundamental human rights. As I said, for example, the Nuremberg laws enacted by the Nazi Germany, which institutionalized what they call discrimination and persecution of Jewish citizens. Yeah, make that comparison today with what's happening in Palestine, where still we can see a systematic appetite system that has been created by the Jews in terms of discriminating against the Palestinians. Palestinians use other avenues as opposed to Jews and other people. So that's another debatable question that you probably want to look at. So you could argue, as I said, from different perspectives. Go to South Africa, where we had these laws, where whites were supposed to do other things and blacks were supposed to do other things. Go to Uganda, for example. We had those laws that began in the early times, Remember, where a certain radius of people, whites were the ones supposed to be in from the city, and then the Indians, and then, the royals, and then the other ordinary people. So you could argue that laws have different contemplations in terms of different societal discourses. So you need to understand that in my opinion, jurisprudence again becomes a question of interpreting how the law forms and manifests and directs society in terms of how it should move. If you're to argue in terms of John Austin again, in terms of the existence of law is one thing, its merits or demerits is another. he was a legal positive, obviously. So I would explain in terms of that. His quote basically is argued in the context of what they call legal positivism, right? And the primary concern was in terms of the existence and the validity of laws as determined by their source and recognition. So the moral quality of law becomes a secondary factor according to them. Yeah, I'll give an example. Speed limits, for example, on roads are a practical illustration. These speed limits are established by government authorities and enforced by the legal system. Yeah, legal positives would actually consider these speed limits as valid laws since they are enacted and recognized by the appropriate government bodies. Yeah, so whether individuals agree with, or find the speed limits morally just or unjust is a separate matter. So legal positivism concerns itself with the legal validity. Yeah, and that's something you must understand as a takeaway. I'll give again just another example for purposes of comprehending in terms of natural school of law. John Finnis, when he says that natural law theory upholds the law and morality that are deeply connected, if not identical, in terms of law, in his view, that is a dictate of reason. Yeah, John Finnis's quote basically, without any shadow of doubt, reiterates the idea that, again, in terms of natural law, these laws are so closely linked to morality and ethical principles, and laws should actually reflect reason and moral values. So it's important, as I said, to comprehend. If you are to argue in terms of an example, consider issues, for example, related to the legality of torture. Yeah, in most democratic societies, there are actually laws against torture, not so including our country here. So these laws are often grounded on the principles derived from human rights, yeah, and international law, as it were. So from the natural law perspective, these laws align with moral values and the dictate of reason. Not so in terms of protecting individuals from inhuman treatment, for example. So this demonstration of how natural law influences the legal prohibition in terms of practices are deemed morally reprehensible. Perhaps a better question would ask if whether or not LGBTQ rights could be argued in terms of what? Positives or in terms of natural law? Anything that offends the order of nature? You guys can think about. Perhaps we should have another discussion when we introduce our book, Strict Mythology, when we're trying to comprehend in terms of the applicability of whether nature versus nurture, in terms of what Professor Hart says, the dispensation in terms of morality versus what? But privacy versus public in terms of the dispensation, but also in terms of substantive cases, even beginning from the UN Convention, and then African Charter, and then substantive cases, Oberberg, for example, and others like what? Like Eric Githari, and others like what? Like Nabakesera versus Attorney General. Yeah, so some of those components, we shall argue them in that perspective, and we will understand why people think that way, and then drive it up to Machiavellics in terms of the argument of the dispensation of the Yellow Movement, perhaps. St. Augustine was an interesting one in terms of the natural. St. Augustine, a prominent early Christian theologian and philosopher, made significant contribution in terms of the development of natural theory. His work, particularly in his book called The City of God, what they call De Civitate Dei, had a profound influence in terms of Western legal and even moral thought. Yeah, and in terms of natural law, St. Augustine emphasized the idea that true laws are actually derived from what they call eternal and divine principles. Yeah, he believed that human laws should actually be rooted in and conform to God's laws, and that just laws are those that align with God's moral order. Yeah, the guy has a point, doesn't he? I don't want to bias you, but we're just having a dispensation in terms of jurisprudence. In terms of practical implications, St. Augustine's natural law theory has actually influenced the understanding of morality and justice in terms of law and society. His ideas have actually been given particularly, influential in terms of development of what they call Christian jurisprudence. For example, the idea that human laws should actually be consistent with divine and natural principles has actually shaped ethical foundations in terms of the legal systems predominantly in Christendom, yeah, or Christian society for that purpose. You want to look at a book called Intelligent Design, and the African Ontological and Epistemological Aesthetics. When you argue in terms of legacy, St. Augustine's work has actually had a lasting impact in terms of legal philosophy, in terms of the relationship between religion and law. His emphasis, for example, on the primacy of the divine moral principles in terms of guiding human law has actually resonated through the history of the Western legal thought. Yeah, and in terms of relevancy, even today, St. Augustine's contributions in terms of natural law continue to be relevant in terms of discussion of morality, in terms of justice, in terms of ethical underpinnings of the law, especially in the context of religious and moral values, which play a vital significant role in terms of shaping the legal reforms. Which reminds me of Desmond Tutu theory of what revolutionary theology. Not so. We'll get there. And then St. Augustine's ideas have actually left a profound imprint in terms of the philosophy of law, particularly in matters of morality, justice, and the influence of the divine or natural law in terms of the legal systems. And so his work basically remains a very, very important part in terms of the broader conversation about the relationship between law and ethics. And one of St. Augustine's most famous and perhaps influential quote is, "An unjust law is no law at all." Yeah? An unjust law is no law at all. Some of you have watched that movie called The Great Debaters. There was a lot of influence on that, and I would encourage you to look at. So this particular quote basically escalates his strong emphasis on the importance of justice and moral principles in terms of the evolution of laws. St. Augustine believed that for the law to be considered valid, it must align with the higher moral standards and the divine order. Yeah, and this particular quote has had a lasting impact in terms of the discussion of law, justice, and the morality in terms of legal philosophy and theology. So it reflects on the conviction of laws that actually deviate from the principles of justice that are fundamentally flawed. Yeah. So it's important. If I'm to make a case in terms of that particular dispensation of unjust law is no law at all, and I'm not calling for what a jurisprudential revolt of sorts, but perhaps call it a reawakening. Yeah. Let's argue in terms of civil rights movements, for example, and I will give an example. During the civil rights movement in the US, for example, there were segregation laws, commonly referred to as the Jim Crow, remember laws, which enforced racial segregation and discrimination to the extent that a black man was actually referred to as 3/4 of a human being for a long time in the Constitution of the US. Yeah, and the fact that you couldn't sit in a bus, you couldn't do so many things. St. Augustine's quotes basically found resonance in terms of the individuals and activists, including people like Martin Luther King Jr., who's my guy and mentor, who argued that these segregation laws were not true laws in terms of the moral sense because they violated the principles of equality and justice. And so civil rights movement sought to challenge and change these unjust laws, highlighting the idea that law must align with the higher moral standards to be considered legitimate. Not so. Another dispensation in terms of practical aspects would be the apartheid in South Africa, not to mention the one in Palestine, between Israel and Palestine. That's another hot cake. So apartheid, for example, was seen as legalized in terms of segregation, in terms of discrimination in South Africa, even in Palestine. So these laws enforced racial hierarchy in terms of what they call disenfranchisement in terms of non-white citizens. If you're going to apply that, you could argue that St. Augustine's quote is relevant in terms of the concept of apartheid within and outside South Africa, and even Palestine, Israel. And we're arguing that the fundamental these unjust violating principles in terms of human dignity and equality. These are sorry states or sorry situations that we consider unlawful in terms of the moral perspective. Yeah, and then we could also argue them in terms of what they call authoritarian regimes. Yeah, authoritarian regimes, maybe like the Nazi, perhaps, and other terrible regimes which had excessive, severe human rights abuses, including genocide, mass deportation, and even widespread oppression. Yeah, I mean, Africa is no guest to that. St. Augustine's quote can actually be applied in terms of those situations that have argued that under these laws, these regimes were actually not genuine, but they were instruments of oppression. I just gave the so-called Nuremberg trials, and then the issues of the Rwanda challenges, the genocide. I mean, a little bit of Uganda sagas in terms of the political instability that we've had, the issues in Southern Sudan, for example, or Sudan for that purpose, in Congo. You can mention anywhere where we have had many of these challenges. Now, in terms of modern human rights debates, the ongoing debates in terms of human rights, such as those related to torture and capital punishment and discrimination, continue to invoke St. Augustine's quote in terms of application. So these contemporary contexts in terms of the importance ensure that the laws align, as I said, with the higher moral human rights standards. And critics of practices like torture argue that such actions are not in accordance with just laws based on principles of human dignity and the prevention of inhuman treatment. Yeah. So we are here contemplating and understanding that St. Augustine's quote has actually been invoked in various historical and even contemporary contexts to emphasize the idea that laws must be just, as I said, morally defensible, and be considered legitimate. So basically, it will help us comprehend that these enduring principles that unjust laws which deviate from the higher moral standards should not be recognized as true laws in the moral and ethical sense, as it were. We'll also comprehend that in terms of the philosophy of law, we have continued it has continued to evolve and even adapt in terms of modern challenges. And would want to argue that in terms of how jurisprudence in terms of modern perspective has asserted or itself. You would begin by arguing it in terms of what they call the critical legal studies, for example, what they call CLLs, which emerged in the 20th century as critical approach in terms of the study of law. It questions traditional legal concepts and challenges the idea that law is objective and neutral. So CLF scholars examine how law, for example, can be used in terms of maintaining perpetual social and even economic inequalities. In terms of relevancy, CLC has actually been influential in terms of highlighting what they call issues of social justice, inequality, and the role of law in terms of enforcing the power imbalances. Yeah. Then someone can argue in terms of what they call feminist jurisprudence. In terms of feminist jurisprudence, it explores the intersection of gender, for example, and the law. By the way, look at a book called Gender and the Law of Gender, Disability, and the Law in Uganda. And in terms of social aspects and the legal principles and practices, in terms of how they explore and how the gender challenges in terms of biases and discriminations in terms of the legal system are actually, enhanced. Feminist jurisprudence has had a significant impact on issues that relate to women's rights, for example, to family law in terms of reproductive rights and gender equality within the legal framework. That's something you must comprehend and understand. Then another modern aspect in terms of jurisprudence will be law and economics. In terms of law and economics, also known as the economic analysis of law, applies economic principles in terms of analyzing legal rules and institutions. It assesses, for example, how law and legal systems affect what they call economic behavior in terms of efficiency and in terms of social welfare. If you're arguing in terms of relevancy, then this approach has actually, influenced, policy decision in areas, for example, antitrust or environmental regulations or intellectual property, where economic efficiency and cost, benefit analysis are actually central in terms of consideration. Yeah. In terms of another modern jurisprudential movement, you could argue in terms of the called critical race theory, what they call CRT. CRT is an interdisciplinary approach that examines how race and racism intersect with the law. It explores, for example, the ways in which the law and the legal institutions have actually contributed in terms of racial inequality and discrimination. In terms of relevance, CRT has actually been crucial in terms of addressing what they call issues of racial injustice, in terms of civil rights and the impacts of systematic racism within the legal system, as it were. Another in terms of what they call global and international law. When you're arguing that, then you must understand that with the increasing interconnectedness, for example, of nations in terms of global and international law, this has also gained a lot of prominence. These areas actually address legal issues that have transcended what they call national borders, such as international human rights law or even international trade law and even environmental law. Yeah, in terms of relevancy, global and international law are actually essential for addressing what they call transnational challenges in terms of promoting peace and ensuring cooperation among the nations. Yeah, and then another modern form of jurisprudence would be what they call neuroethics and the law. Yeah, neuroethics and the law. In terms of as an emerging field, neuroethics examine the ethical and legal implication of advances in what they call neuroscience, for example. So questions related to cognitive enhancement, for example, mental privacy, and the use of what they call neuroscientific evidence in terms of the legal system are becoming increasingly relevant. Yeah, and therefore, in terms of relevancy, as as our understanding of the brain and human behavior advances, the law must actually adapt to address the novel ethical and legal dilemmas. Yeah, look for our book, Guardians of the Mind. Again, we try to underscore some of those things. So these modern forms, in terms of the philosophy of the law, reflect basically the dynamic nature in terms of the field, in terms of addressing what they call contemporary social and even political, even technological issues. They provide critical perspectives in terms of frameworks which help us understand and improve the legal systems in terms of our rapidly changing world. Yeah, I'm going to give you some other interesting emerging areas within the philosophy of law. Yeah, and as we argue that, then we're opening up our brains, as I said, until we find ourselves to AI, and then the Musevenics, and then the Red Power movement or People Power movement, stuff like that. Okay, so in terms of environmental jurisprudence focuses basically on legal and ethical considerations related to environmental protection, for example, in terms of sustainability, climate change, and basically it examines the rights and nature and the legal responsibilities of human towards the environment. Look for our book, Climate Change. Look for our book, Environmental Law and Sustainability. So given the increasing global concern in terms of environmental issues, these areas of jurisprudence play a very crucial role in terms of shaping environmental policies and the law. Yeah? And then in terms of, again, jurisprudence, you may want to comprehend in terms of technology and the law as an aspect of jurisprudence. Yeah, and that's that's my drum major in terms of saying let's revolve with rapid changing technology. For example, in terms of advancement, philosophy of law is adapting to address issues related to privacy, for example, cybersecurity, intellectual property, and even emerging technologies like artificial intelligence and biotechnology. We have written books in those areas, by the way. In terms of relevancy, the interplay, obviously, between technology and the law has a significant implication in terms of the individual rights, in terms of societal norms, but also in terms of legal regulations of emerging tech industries. Yeah, look for a book in terms of legal personhood, for example. Look for their book called Future Lawyer. And then if you're arguing in terms of restorative justice is an approach, for example, in terms of criminal justice that enforces on repairing harm and addressing the needs of victims in terms of offenders, in terms of community. It seeks basically to provide what they call alternative to traditional punitive approaches. Look for a book called Ubuntu Gulam and the Law. We make that advocacy. So in terms of restorative justice, it challenges what they call conventional punitive legal processes and is seen as a way of promoting what they call reconciliation, in terms of healing, in terms of what? Rehabilitation, for example. What some people call Ichacha or Matoput or what? Ubuntu Gulam for Ubuntu in other jurisdictions, or perhaps what? Arabian, stuff like that, yeah? In terms of legal ethics examines the moral and ethical responsibilities of lawyers and even legal professionals. It addresses issues in terms of the conflicts of interest, in terms of what they call, for example, client confidentiality and the lawyer's duty in terms of the court, yeah? Look for a book, The Attorney or the Titulate Legal Lawyer or the Titulate Lawyer in terms of jurisprudence, the art of what? Of perfecting public speaking and the like. So it helps you in terms of professionalizing yourself and ensuring what they call fair administration, and also in terms of dispensation in terms of your arguments, yeah? So another would be in terms of culture and indigenous jurisprudence. Culture and indigenous jurisprudence explores the legal systems in terms of practices of indigenous and marginalized groups, yeah? As I said, Ubuntu Gulam and the Law is a good book to start with, but we also have another book, The Law of Special Needs. That's another one that can help you to comprehend these areas. So these areas are vital in terms of recognizing and respecting these legal traditions in terms of the indigenous and the minority groups within the context of broader legal systems, yeah? So please understand that these modern and emerging areas in terms of the philosophy of law reflect, as I said, the evolving nature of the legal field, and they help address these complex and even interdisciplinary issues that impact individuals and societies and also the global community in terms of providing what they call valuable insights for shaping the future of the legal system and justice. Now, another interesting one that is super interesting is what they call artificial intelligence, which is increasingly becoming an issue in terms of intersecting within the field of law, leading to the development of what they call new subfields and perspectives. So I'm going to give you some areas in terms of intersection of AI and the philosophy of law, yeah? And I'll begin with what they call AI and legal ethics. Look for that book, The Future Lawyer, because we make those dispensations. Now, AI application in terms of the legal profession raises what they call ethical questions about the use of algorithms in terms of decision making, in terms of confidentiality, in terms of what? Delegation, in terms of the legal tasks to machines, yeah? Now, if you had to argue that, you'd understand that AI addresses concerns that are related to fairness, transparency, and accountability in terms of responsibility of lawyers and even legal professionals when they're using these so-called AI tools, yeah? And we make a heavy dispensation in terms of that. And look for that book, as I said. So AI in terms of legal research and analysis, for example, AI-driven tools and platforms are being used, for example, in terms of legal research, in terms of contract analysis, in terms of due diligence. These technologies usually assist lawyers in terms of analyzing vast volumes of legal documents more efficiently. So it's important as a relevancy to argue that the use of AI in legal research has actually implications in terms of how legal professionals, for example, approach case analysis and document review in terms of legal reasoning, yeah? And then the use of AI in what they call predictive policing and criminal justice, yeah? AI, for example, is empowered in terms of predictive policing, in terms of forecasting potential criminal activity. It's also used in sentencing recommendations, for example, and even raising questions about bias, transparency, and fairness in terms of AI-driven decisions. Look for that. Find out about that AI called do not pay that was charged for practicing without a license. And then find that book. You're gonna find all the things in our book called The Future Lawyer. And then if you argue in terms of AI, intellectual property law, then you may want to look at legal personhood, the book that wrote on legal personhood, but particularly in terms of AI-generated content such as art, music. By the way, we've written a book called Music and the Law. In terms of challenges, in terms of traditional copyright, in terms of intellectual property, look for a book called The Internet of Things, yeah, and then cybersecurity. All those in terms of AI-generated works, they are indicated there. So, as I said, the intersection of AI in terms of intellectual property poses questions about creativity, about authorship, and the need to update these legal frameworks in terms of having an accountable, accountability in terms of AI-generated, data or control, as it were. Then AI and data privacy law. Well, the AI systems often rely on large data sets, raising concerns about data privacy, consent, and the protection of personal information. In terms of privacy law, which must adapt to what they call AI-related challenges. So privacy and data protection laws must actually evolve in terms of safeguarding individuals' rights and freedoms. And so therefore, an AI-driven world, particularly in the context like automated surveillance and data analytics, need to be comprehended very, very well. And then still, if you're arguing AI in terms of what they call autonomous vehicle law, yeah, the development of self-driving cars, the likes of Tesla, yeah, involves legal consideration in terms of liability, in terms of safety, in terms of regulations, in determining response in terms of accidents, in terms of autonomous vehicles, that a complex legal challenge. So AI's role in terms of autonomous vehicles requires what they call a re-evaluation of the legal framework to accommodate the novel aspects and the challenges posed by these self-driving technologies, right? So as I said, these modern intersections between AI and the philosophy of law underscores the need to adapt legal theories and principles and even frameworks to address emerging challenges and opportunities presented by artificial intelligence, yeah? And they reflect on the ongoing evolution of the legal field in terms of the response to technological advancement, yeah? I would not even go in terms of arguing AIs or robotics that now are perhaps encouraging in human relationship, body-to-body relationships. But then there's an interesting one, another called transhumanism. Transhumanism basically is a philosophical and cultural movement that advocates for the use of technology and science to enhance what they call human capabilities and transcend the limitations of human condition, yeah? So it aims, for example, to improve and extend human life in terms of intelligence, in terms of physical abilities, and overall well-being. So transhumanists believe in the potential of what they call advanced technologies, such as genetic engineering, artificial intelligence, and biotechnology, to augment human abilities and even achieve a post-human existence, yeah? Now, those of you who may want to understand what transhumanism come from, transhumanism emerged in the mid-20th century, which was popularized in the 1980s and 1990s. And the term transhumanism was actually coined by a guy called Julian Huxley, an evolutionary biologist and a proponent of human enhancement. And key figures in terms of movement include people like Max More, Nick Bostrom, and Ray Kurzweil as well. And they've written extensively on the subject. So the movement draws inspiration from science, fiction, ethical philosophy, but also futurist thoughts, as we're trying to argue here. In terms of its impact and application, it has had an impact in terms of what they call health and longevity. Transhumanist ideas have actually influenced what they call medical research, for example, and the development of what they call therapies for extending human lifespan and actually improving health. So this includes areas like regenerative medicine, gene editing, and even personalized medicine, yeah? And if you argue in terms of artificial intelligence, we can argue that the quest for a super intelligent AI aligns with what they call transhumanist goals, yeah? So AI technology is actually being developed for various applications, including natural language processing, for example, your ChatGPT, and then image recognition, and then autonomous systems, yeah? And then there's what we call chronics. If you argue in terms of chronics, transhumanism explore chronics as a means of potentially reviving people who have actually been chronologically frozen after legal death. So it's an attempt to cheat death and extend life. These things are going to be a reality. I've seen them, I've heard about them, And then there's what they call mind-computer interfaces. In terms of advances, what they call brain-computer interfaces, neuroprosthetics, and also neurotechnology that aim to enhance human cognition, memory, and even communication, which is in line with what they call transhumanist ideals. Yeah. And then if you have to argue in terms of what they call future implications, yeah. In terms of future implications, you would be quick to understand that when you're arguing future implications, we look at it in terms of what they call ethical and philosophical considerations. Transhumanism basically raises fundamental ethical questions about the potential consequences of what the enhancing human capabilities in terms of issues of equity or even access or even consent and safety, which will become very central in terms of future debates. Yeah, and then also another dicey part would be in terms of societal and legal changes. Yeah, so as transhumanist technologies advance, there will be a need to, for a new legal and regulatory framework to address these issues such as human augmentation, AI rights, and even transhumanist medical procedures, as it were. And then another aspect would be in terms of culture and even identity shifts. Yeah, transhumanism may actually lead to what they call a re-evaluation of what it means to be human and the boundaries of human identity. And this could actually spark debates about the meaning of humanity itself. Not so interesting. But also, if you have to argue in terms of the global impact, then you would understand the development and the distribution of transhumanist technologies will likely have a global impact in terms of potentially leading to disparities between those who have the access to, enhanced and those who actually do not. Yeah. So basically, what we are comprehending here is that transhumanism, as I said, is a philosophical movement that seeks to harness technology to transcend human limitations. Yeah, and is shaping the future in areas ranging from healthcare and AI to ethics and even identity, which with profound implications in terms of society. Yeah, in terms of policy, in terms of understanding what it means to be human. So the impact of transhumanism will actually continue to evolve as technology progresses and as society grapples with the ethical and legal implications in terms of human, enhancement. Yeah. Other things that are important for us to consider in arguing transhumanism in terms of jurisprudence, future jurisprudence, is what they call existential and ethical questions. Yeah, transhumanism raises profound existential and even ethical questions about the nature of humanity in terms of consciousness and the potential consequences of altering the human condition. Yeah, so these philosophical discussions explore topics such as the potential loss of human identity, as I say, the pursuit of immorality, and then the ethical boundaries of human enhancement. Yeah. Now let's argue just for starters what we mean by post-humanism. Yeah. When you're arguing transhumanism, it can actually be seen as a stepping stone towards what they call post-humanism in terms of theoretical future stages where humans may actually merge with technology to create an entirely new form of being. Yeah. So post-humanism, especially post-humanist thinkers, consider concepts like digital consciousness, mind uploading, and the idea that the future entities may actually bear little resemblance to the current humans. Yeah, that's an interesting discourse. Okay. And then in terms of societal and economic equity, for example, the development of transhumanist technology, for example, raises concerns about equity and access. And it's important to consider how, enhancements may actually be, distributed, whether they will actually exacerbate societal inequalities or whether they will actually be accessible only to a privileged few. Yeah. And if you have to argue in terms of legal and regulatory challenges, then the integration of transhumanism technology, for example, into daily life and healthcare will actually necessitate what they call legal and regulatory frameworks, ensuring the safety and ethical use of human, enhancements, as well as addressing issues like informed consent, data privacy, and liability, which will become super vital. Yeah. And then if you're arguing in terms of what they call biosecurity and technological risks in terms of the advancement of what they call biotechnology and AI in the context of transhumanism, it carries potential risks including biosecurity concerns or even the misuse of what they call genetic engineering and unintended consequences of AI. Developing responsible governance and safeguarding will actually become extremely important in terms of that. Then if you have to argue that in terms of what they call public perception and values, then we will comprehend and understand that the acceptance of transhumanism ideas and technologies will actually depend on public perception and cultural values, as it were. So no doubt that debates around these topics will actually involve a wide range of stakeholders, including ethics, scientists and policymakers, and even the general public. So as I say, transhumanism basically is a multifaceted field that basically encompasses not only on the pursuit of human enhancement, but also on profound ethical and philosophical and even societal considerations. So as technology continues to advance, the discussion and debate surrounding transhumanism and its implications in terms of humanity will remain at the forefront in terms of evolving relationship with technology and the future of human existence. Yeah, so it's important for us to comprehend that is extremely important. I would like to point out some proponents perhaps who have been instrumental in terms of making a mark in terms of a dispensation of AI for the world today, and particularly one that comes to mind, of course not neglecting those who are behind the curtains, the engineers, is your guy called Elon Musk, who has actually expressed concerns about the potential development of what they call a super intelligent AI system that could actually surpass human intelligence. His concerns are often associated with the idea that AI could actually become uncontrollable or even make decisions that are not aligned with human values. Yeah, and Musk has actually advocated for a cautious and responsible AI development, and has even founded organizations like OpenAI to ensure AI safety. Yeah. On the other hand, there are AI and even what they call transhumanist researchers who are more optimistic about the possibilities of achieving what they call digital consciousness, or even creating AI entities with what they call advanced cognitive abilities. And they see the potential for AI and robotics to enhance what they call human capabilities in terms of addressing complex problems, and even contribute to the emergence of what they call digital consciousness and post-human entities. Yeah. So as we argue that, we must understand that the debate essentially boils down to the question of risk versus reward, not so. So Musk's position emphasizes the risk of unchecked AI development, while others may actually focus on what they call potential benefits in terms of including the idea that advanced AI could actually lead to new forms of consciousness, or what they call human augmentation. And that is something very important for you to understand. So my friend, it's a complex and ongoing conversation, as I said, that encompasses a wide range of viewpoints and ethical considerations, and therefore the tension between these perspectives reflect the broader discussion surrounding the ethical and philosophical and even practical implications of AI and its impact on the future of humanity. Yeah. In terms of some other people, perhaps who may have comprehended or written extensively, other than Elon Musk, we have some colleagues in terms of notable figures who have actually made significant impact, and I'm going to try to mention a few of those so that we comprehend and understand where they're coming from. I mean, not so detailed, but as jurisprudence, so it's going to mention them anywhere. There's a guy called Ray Kurzweil. Ray Kurzweil is a futurist and AI expert known for his optimistic view in terms of AI and its potential to enhance human life and even achieve a form of digital consciousness. He has written extensively on the topic in terms of AI and the singularity, where machines' intelligence surpasses human intelligence. Yeah, your guy whom you like very much, Mark Zuckerberg. In the past, Mark Zuckerberg, the co-founder of Facebook, now Meta Platforms Inc., had different views from Elon Musk. Zuckerberg has actually been more optimistic about AI and its potential in terms of benefit to society, especially in areas of healthcare and even education. Then there's a guy called Demis Hassabis, okay, what they call Hassabis, some people Hassabis. Demis Hassabis is the co-founder of what they call DeepMind, a leading AI research lab. DeepMind has actually made significant advancement in terms of AI, particularly in areas like reinforcement learning, while Hassabis has not actually been so direct in terms of opposition to Musk. DeepMind's work reflects a more optimistic perspective in terms of AI. Yeah, so these are some guys that come to mind in terms of comprehending what they said or what they did in terms of the field of AI. But as I said, as a growing area of jurisprudence, which we cannot neglect. As I said, look for that book, Legal Personhood. The idea that machines are going to come up with inventions, and you have syllables or codes or algorithms fitted in them, and you tell it, do this for me. Who will own it? Is it the machine or you who is giving the instruction? Without you directly, dictating that I want it to be this way, but I want this. It's another thing as opposed to coming up with the thing itself. There's another guy who has contributed quite well. I think he wrote a book, The Grand Design. The guy called Stephen Hawking. Some of you probably know him, a renowned physicist. He passed on, of course. Stephen Hawking expressed concerns about the potential risk of advanced AI, suggesting that it could actually pose an existential threat to humanity if not properly controlled. Yes, yes, there's no doubt about that. Anything that uncontrolled will have, repercussions, no doubt about that. There's another guy called Nick Bostrom. Nick Bostrom is a philosopher and actually the author of what they call Superintelligence, a book that actually delves into the risks and benefits associated with superintelligent AI, and has actually been influential in terms of discussions about AI safety for a long time, in terms of long-term risks as well. Another guy called Stuart Russell. Stuart Russell is a professor of computer science and AI ethics advocate as well. He actually emphasizes the importance of aligning AI development with human values and actually co-authored widely used AI textbook as well. So you may want to look out for that book as well. There's another one called Yan LeCun. What they call Yan LeCun. Yan LeCun is a prominent AI researcher and one of the pioneers of deep learning, and he has actually been optimistic about the future AI and its potential to the benefit of society, particularly in the areas of healthcare and even robotics. So that's someone you may also want to look out for. Another one is called Murray Shahan. Murray, he is a professor of cognitive robotics and an AI researcher who explores the intersection of AI in terms of cognitive science. His works have contributed in terms of understanding AI, in terms of potential for replicating aspects of human intelligence. So as I said, these individuals are just among others that have actually made significant contribution in the field of AI in terms of jurisprudence and in terms of wide range of options. So from cautiousness, optimism regarding the development of the impact of artificial intelligence. So the diversity of perspectives in terms of AI community, as I said, reflects the complexity of the subject in terms of ongoing discussions about the potential benefits and risks that are associated with advanced AI technologies. So I could go on and on and on and mention others, but also in terms of jurisprudence, perhaps what I wanted to emphasize is an aspect that had to do with the jurists that we have in Uganda, for example. I just mentioned about Musevenomics. Remember, from the word Musevenomics, as an argument in terms of the dispensation of what the yellow movement or the bus movement, in terms of beginning from the 10-point program, Bonabagagawale, NADS, for example. All those aspects, those ideologies that have been propounded by His Excellency, the President Yoweri Kaguta Museveni, in terms of the ideology that's propounded, and the Chankwanzi, what's that? What I want to use a simple word. Indoctrination. I hope that's a simple enough. The Chankwanzi indoctrination in terms of an ideology, how the NRM does their things, and what are the advocates say, beginning from one-party system to now a multi-party dispensation to a system that now has NRM fully in power and the majority of NRM members, all those aspects. Someone could argue that ideology in terms of the proposition of the programs that NRM has actually provided for this country could also be used and argued as a dispensation of jurisprudence. Now, whether or not that rhymes with the positive view or the natural school of law is a question of debate. Then there's another movement, of course, by the Red Power movement. The NUP, for example, can also be argued in terms of that, perhaps borrowing from Julius Malema's party. In terms of economic empowerment in South Africa, in terms of the Red Power movement, in terms of the dispensation of fighting for economic rights of people. If you argue that in terms of NUPIA, the ghetto president or the fighting for the ordinary people could also be argued as a movement or dispensation of jurisprudence of sorts. Whether or not that rhymes again with the positives or vis-a-vis the natural school or any other jurisprudence for that purpose is another question of debate. You could also look at other movements, for example, in Rwanda, for example, the revolution that is happening there in terms of His Excellency Kagame, and then you may want to look at other dispensations in terms of even borrowing from the likes of the Nelson Mandela, the Desmond Tutus, the revolutionary theologies, all those aspects in terms of the dispensation of what was happening in terms of how these quote unquote philosophers of sorts, beginning from the likes of Julius Nyerere, the movements in terms of the Tanzania school, that how it has impacted the entire Africa, perhaps even Gaddafi's ideologies of one Africa. We have quite a lot. The likes of the likes of Lumumba, the likes of Nkrumah, the likes of Jomo Kenyatta. All those arguments can be argued in terms of these different dispensations of what? Africology, in terms of the Africology, in terms of the dispensation of African jurisprudence, in terms of aligning ourselves with our norms and values that Turi ascribe or indicate, or perhaps demonstrate the intricacies of our people, African people, in terms of African jurisprudence. So these are schools of thought that I wanted to throw to us, and understanding the philosophy in terms of the law, what we need to comprehend. The philosophy becomes an ideal, or perhaps a vehicle under which all these dispensations may come to. So whichever line you may take, whichever philosophy may appease you, I mean, what they call, for example, legal realists, the likes of Justice Oliver Wendell Holmes, probably widely regarded as one of the brightest lawyers in human history, who said wanting to become a lawyer was divinely inspired. You know, his argument in terms of legal realism, the fact that the law resonates with what? With changing society. What may have been law yesterday may not necessarily be law today. Yeah, in terms of the argument that judicial officers actually do make law. In terms of the dispensations, it's not now although it is fundamentally a preview of the legislature to make laws, but we see jurists or perhaps judicial officers who actually come up and actually do make novel decisions in terms of the dispensation, and these are quote-unquote carried on at law, you know, in terms of precedents that we follow, in terms of the doctrinal precedents. Yeah, so all these aspects again can be argued in the angle of philosophy, in terms of comprehending and understanding the jurisprudence of sorts. So I would encourage you to look at some of our books, for example, Freedom Through the Law, where we make serious arguments in terms of the dispensation of different jurists, in terms of the different schools of jurisprudence, as it were, so that you can comprehend and understand. And we welcome you guys to take time to visit our website, lubogo.org, and suigenerislawup.com, where we try to demystify the law for you. Once again, it's been a pleasure and an honor to listen, to have an interaction with you, and have this substantive debate in terms of the philosophy of law. My name is Isaac Christopher Lubogo. I bring you greetings from Sui Generis, and thank you once again for your attention. Let me take leave. God bless.